So this case law.
Am I a lawyer now?
I was about to say, who found this case law?
Me. No, I'm just kidding.
That's what I was about to get at. You did this?
Well, yeah, I did because I followed the YW Melly case all through and through. I went and I had to go back.
What
and
I'm saying
my
is,
recaps.
has YSL presented, any lawyer in YSL presented this?
No, I'm finna DM them. Yo, let me tell you what I did.
Hold on now. What you just did?
Okay, but it was in Florida though too.
You about to be Exhibit H.
No more exhibits.
You gonna be in Exhibit H. They're watching this when it does post. I guarantee you.
No.
Now, if you're not ready, then go ahead and tell me you're not ready.
I object to you getting records. You've been intrusive into people's personal lives.
In other words, the car didn't hit him, and he wasn't hit by the car.
I'm not a lawyer, but are y'all keeping up? I'm not a lawyer, but
the debrief.
Hello, and welcome to another episode of I'm Not a Lawyer, But
the debrief.
I am Mel, aka I'm Not a Lawyer, But, and I'm joined by my co-host
Gooseberry. How y'all doing?
And we are not lawyers or experts in any fashion, really.
Not at all.
You might be considered an expert in some things.
I'm an expert dad.
All right.
So.
But we are not experts, so this is never any legal advice. If you take legal advice from us, that's your bad. This is literally called I'm Not a Lawyer, but all of that to say, there's been a ton going on and we want to talk about it. And before we do, we want to thank our sponsor of this episode,
Magic Mind.
We're going to tell you more about Magic Mind in the episode. Shout out to them, support us. So this is going to be, Greg wants to talk a little bit about some updates in Karen Reed, which is very important for us to discuss. And then I'm just setting up at the top, okay, that we are going to be talking a lot about YSL because a ton has happened in YSL, but I want to do a bit of a comparison, a little bit of a look back on the YW Melly case because I think it's relevant for me to highlight something that happened in that case. So I'm going to tell you about that. You know, I love a good clip. So we'll play a clip and then we'll talk about the kind of similarities and get some thoughts and opinions. Maybe I'm off base because I'm not a lawyer. We'll see. Anyway, let's get into it. I don't have a mini bar today because I just want to dig into all the other things. So Karen Reed.
Karen Reed. So most of us already have heard about the jurors calling, emailing, reaching out to the defense. Basically stating that they found Karen Reed not guilty unanimously amongst them all, not guilty of count 1 and count 3.
Yep.
Count 1 was like vehicular homicide.
Sure, correct? That sounds about right.
And then count 3 was just straight up murder, right?
No, so count 1, I believe, was murder, and then count 3 was the vehicular. But okay, go ahead.
But yeah, count 1, count 3. Okay. I had it written down, but I can't find it. Okay, but that's what we all know that's been happening. So just recently, the Commonwealth have received the same information from jurors, not knowing if it's the same juror or not, but they say they received the same information. Okay. So the defense is saying, okay, well, now that you've received the same information that we received, I mean, it should be obvious that these two counts should be dropped.
Yeah.
Completely.
Right.
So now they're having a hearing, I believe tomorrow.
Friday, right?
Yep, Friday, to have for
them to argue their motions.
To say drop these charges 1 and 3. But what they're saying is the judge can deny that and still retry Karen Reed for all 3. But Yannetti and the defense is saying it's common sense. If they all have received the same information,
That they should drop it. I mean,
That
it
they
does
should
make
drop it.
what's crazy. It's a motion, so the judge obviously has to rule on it, and they have to provide a legally sufficient and compelling argument such that the judge would rule in their favor, meaning say, you're actually right, this should be dismissed, right? So all of that understood. But what's interesting is that should the judge decide no, based on what happened, it wasn't public, they didn't come in this courtroom and literally say, we find her not guilty. Because of that, the judge can say, this stands. I don't have to order you to drop these charges. Here's the thing that's interesting for me. As the prosecution, even if the judge rules no, as the prosecution, if I know, dang, I didn't do a good job and y'all said she's not guilty, they could still choose not to retry her on those charges. So regardless of what the judge, obviously it would be great if the judge says they can't, but they themselves can still opt not to retry her on that. And I find it, granted it would be trial number 2, so they can change their strategy, they can whatever, they can pivot, but it seems dumb to retry somebody on something in which a jury has already told you, hey, this ain't a good job.
We all
We
decided.
all 12 of
All
us in
12 of
here
us, yes.
were not convinced of what you had to say. So if you are looking for, I was going to say looking for a conviction, but what they should be doing as the Commonwealth is that if you are looking for justice, it seems like your better bet would be to go after the charge that you feel like you can get the guilty verdict on.
So that's what I didn't mention. So the jury also said they were 9-3 in favor of Karen Reed guilty
on
of
count
manslaughter.
2.
Yeah, it was manslaughter. So I mean, there you have it. Drop the other 2 and go after the manslaughter.
That's why it would be, again, the judge can obviously say no legally. There's not, enough for me to order this. But as the Commonwealth, just because she say no don't mean you don't get to say. You can still say no. You could still drop it. So Friday will be interesting.
It is. I think they should drop all the charges. I don't see how they would even come up with the manslaughter case, because in that case, for them to say that she is guilty for manslaughter, they're saying that she hit him with the car. The evidence shows that she didn't. So
but not for them. I mean, if the jurors were convinced of it, then we have our own thoughts. But if all I'm saying is, if I was a prosecutor and I get this information, I would be like, oh, so I'm not going to retry you on those 2. And if it was 9-3 on this one, I'm going to go all in on this one, try harder.
Those 3.
Yeah, somebody in the Patreon is asking, can they change the evidence? It's essentially a new trial. So they can completely use a different strategy. They can do what they choose. So if you're starting fresh, but you have the advantage of having a look at what you did bad, that's like, I get to see your hand in a game of cards. I'm going to address appropriately.
So they could even say they could take the whole vehicle situation out of the whole case then. The Commonwealth, they could say she didn't kill him with the vehicle. If they wanted to, they could take that out.
Sure. I mean, sure. Sure.
I'm just saying, because it seems like the vehicle, they said 9-3. We don't know, because this is what they're saying, 9-3. We're not sure if it's real or not, but I don't see how they convinced 9 people that she hit him with the vehicle. That's baffling to me. But like you said, I'm saying that because you said it could be a new case and they can approach it totally differently. And that's what I'm saying. I wonder if there's another way they can present it without the vehicle being involved to then convince people that she accidentally murdered the man. That's all. Because if the vehicle still is in the story, they won't ever get a conviction.
Well, somebody also just commented they are going to have new jurors though, and they might think she is innocent, and that is true. With a new trial, you get a new juror, so a new jury. So I convinced, a jury of 12 on this last one that she was not guilty, or the jury found that she was not guilty. They can still take the gamble and say we can pivot and do a better job and try again with all three. That 100% can happen. I'm just saying, me personally, I'm not finna gamble on a brand new 12 when I've already gotten insight that the last 12 said no, no, no to 1 and 3. But I mean, we'll see what happens. We're not lawyers, so we'll see what happens with what we'll see what happens with what the judge decides. What happens first, they'll present to the judge. She gets to make the ruling, and then the Commonwealth themselves can decide if we do it again, which ones we do it again on, what that looks like.
That's interesting because I didn't take into consideration the new jury. So that'll be interesting.
Yeah,
because they're probably going to have a jury consultant.
Well, maybe if they hire one, we can have them on the podcast. Also, you should get ready for that ad. But while you are doing that, I just want to say that so I don't remember if I said this already. Obviously, we don't have a guest today, so it's going to be us talking about stuff. That is the setup. We've been having a lot of guests, and we'll have more amazing guests. But this episode, you get us.
Doing the show and doing ads, I have to be mentally right and ready, right? So using Magic Mind will help you focus a little bit more, and some it'll help you focus a lot. Okay, Magic Mind is a mental stability shot. Okay, it helps you focus on the task at hand. All right, and they use 100% safe ingredients. They also have over 200 scientific studies behind each ingredient, like lion's mane, turmeric, and ashwagandha. This company also helps out the environment mentally by giving 5 cents to mental health to help the homeless for every bottle sold. Myself, I've been using it for probably a week now. So every morning I get up, I shoot the shot, and then I go work out, and then I get to work, and I feel clarity. What happens is when I go work out, I can start scrolling on my phone and get unfocused. But ever since I started using Magic Mind, I don't scroll. I focus on my workout. I know it's not a pre-workout. Okay. That's not what it is. It just helps you focus on the task at hand, and it helps me work out. Magic Mind, I recommend it. I like it. If you like green juices that taste, that's how it tastes to me, and it's outstanding for me. You have a limited offer you can use now that gets you 48% off your first subscription or 20% off your one-time purchase with the code lawyer at checkout. You can claim it at magicmind.com/lawyer.
Thank you, Magic Mind.
Magic Mind.
If you order it, use it, try it, enter the code, and then tell us what you think. Because we have packs at home now. We are all in.
It comes in a unique box, and you'll think it's just a regular package. So be wary of that. You have to open it up, open the box, and you'll see all these shots of Magic Mind.
All right, let's get into, we still will call it the open bar, but it's, I want to talk about YSL. A brief setup before we get into the YW Melly part. If you are not aware, they obviously have been on a break in the YSL case for over a month now because the judge was recused. The original judge, Chief Judge Glanville, was recused from the case. And so a new judge has been assigned, Judge Whitaker, and she is not playing. She has been rolling through everything that's been going on, trying to get caught up to speed. And so they've been having a ton of motions, a ton of hearings regarding motions that have been filed. Some of the motions that have been filed include a motion to recuse the prosecutors, to recuse Attorney Love and Attorney Hilton specifically. And originally, that was asked, or that was included in the motion because Brian Steele, which is Young Thug's attorney, said that they were witnesses to the ex parte and therefore are witnesses in the case, right? And so he asserts that this ex parte, this secret meeting happened with this star witness, Kenneth Copeland, aka Woody. There's this secret meeting that happens, and in that meeting, there is coercion, okay, to get Kenneth Copeland to agree to testify. He originally said, I'm not going to testify. And at the end of this meeting, he changes his mind and agrees to testify. And so because the prosecutors and the judge were present in that meeting, Brian Steele says, I want to call y'all to the witness stand to talk about the fact that you guys coerced him, right? And so if you are coerced to testify against my client, okay, that is an impeachment. Basically, I have the ability to call you out and tell the jury they convinced him. Is what he's saying trustworthy? Essentially, is what you're getting at, right? Like, you guys convinced him to get on this stand, and so can you really take what he said? And in addition to that, you guys are the prosecutors. You guys are supposed to be the state, representing the state. And so if you would participate, you and the judge, if you all would participate, right, in this secret illegal meeting in which you convinced a witness to testify against my client, are y'all even fair? Are y'all even the kind of people that should be representing the state? That was a very broad, generalized summary, okay? If you need the full recap, go watch I'm Not a Lawyer But videos. But for the sake of this podcast, I just wanted to kind of set up what is happening and a little bit of why and why this kind of matters.
So if the judge was recused,
Yeah.
why wouldn't the prosecution, why wouldn't they be?
Well, they both served, the judge and the prosecutor serve different roles in this case.
Well, the prosecutor is the state.
Yeah.
The judge is the state.
Well, the judge is not supposed to be the state. The judge is supposed to be this fair tribunal. The judge is supposed to be this kind of independent referee, a referee of the court to say, yes, you can go. No, you can go. Yeah. Like this, that's supposed to be the case. They're not prosecutors.
On teams.
No, they're not supposed to be.
Well, I think if the judge had to leave, the prosecutors should have to leave as well.
Well, you have to present different. Okay.
Because of the same reason the judge had to go.
Yeah, but the judge, he was not recused for that necessarily.
Okay. What was he accused? Recused for?
They asked that he be recused for having the ex parte. The reason he was actually recused is because when a judge is presented with a recusal motion from an attorney, when an attorney says, hey, judge, you're being unfair, you should be recused, the judge is supposed to go through 3 kind of check marks and then refer the recusal to another judge to decide if they should actually be recused.
Okay.
The reason he was recused is because the judge said, instead of going through your 3 check marks, you instead sat up there and tried to defend yourself. You instead tried to present all of this information as to why you shouldn't be recused. And then at the end said, okay, now I'm going to send it over. So the judge was like, because you did that, you are recused, not because of you having the ex parte. So that's not why he was recused. Because thus far, they have not found that they, meaning other judges, that judge in particular has not found that the ex parte was illegal.
Okay. And I agree with the prosecutors being stepping on the stand and being called out.
Well, it's a big deal. That was also something I was going to go into. It's a big deal when attorneys are called to the stand.
Yeah.
And there are a few that I have was going to do a whole section on where we were going to talk about some of them. I'm not going to do that because I want to talk about the similarity to YW Melly. But that is what has happened, right? They have asked for Brian Steele has filed a motion for the prosecutors to be recused. They have also filed a number of motions at this point for this trial to end in a mistrial. They are saying, hey, judge, we've come too far. This is way off the tracks. This is unfair, constitutionally unfair to our clients, and therefore you should grant a mistrial. This trial should end. And so there has been a number of motions, including by Doug Weinstein, who was on this podcast, presented a motion arguing that it should be a mistrial with prejudice. There has been Bruce Harvey, another attorney, presented one saying that it's unfair that this judge would come in at this point. So all of that to say, a bunch of people saying that this should end in a mistrial. I just wanted to go through the setup. We'll talk about more, but that's the setup. Now, before we go into the rest of it, I need to tell you about YW Melly, because the prosecutor on the original YW Melly case was recused after the trial. So what happened, and it had to do with Brady. We've talked a ton about Brady, right? We talked about what happened in Alec Baldwin. Brady information was not given over to them, and that judge felt it was so terrible. She said, it's over. Everybody can go.
And they called the prosecutor to the stand on that one,
They
too.
called the prosecutor to the stand. So in YW Melly's case, brief setup is that Jamel Dimmons is aka YW Melly, and he is charged with shooting and killing two of what were supposed to be his childhood friends, and then staging the scene to look like a drive-by. That is the setup. He had a trial. It ended in a mistrial. The jury it was not unanimous, and so it ended in a mistrial. Following the mistrial, okay, his lead attorney left. I don't know why, but he got a new attorney. When that new attorney came on board, they filed a motion to have the prosecutor, her name is Christine Bradley, to have her recused. And the basis for their motion is that the lead investigator on that case, whose name was Detective Moretti, okay, Detective Moretti was having I don't know if you would call it a meeting, but he had went to another precinct's office and is doing some questioning of YW Melly's mother. Her name is Jamie King. Jamie King at this point has Melly's phone. They're saying her phone, but it seemed like it was Melly's phone. And then when he got locked up, she kept the phone. And so they're in this conference room at this precinct that is not the home base of Detective Moretti. And during this meeting, he has a search warrant that allows him to get the phone from Jamie King. When they're there, the Broward County officers, so I think they're in Broward County's office or station. The actual officers of that station leave the room, okay? And when they leave the room, Detective Moretti, lead investigator on this case, tells Jamie King, we have a warrant to get that phone. And so she starts allegedly fumbling with, you'll hear some more of this. She starts fumbling with her phone, and he the claim is physically takes it from her, takes it out of her hand. She is injured to some degree of that happening. And then because apparently he was not supposed to execute a search warrant without the presence of officers whose jurisdiction that actually is, right? Because he's out of his jurisdiction executing a search warrant. So even if you think about Karen Reed, remember when they went to her mom's house, they called officers whose county that was to come meet them. So kind of along those vibes, right?
Okay.
So when he gets the phone, he then allegedly tells one of the officers whose jurisdiction it was, one of the actual officers, hey, say you was in the room the whole time.
Oh, man.
And so after the trial happens, the defense learns about this, okay? And there actually ends up being an internal affairs investigation into Detective Moretti for excessive use of force because he forcefully took that phone. And it seems to be a little bit up in the air if he was even able to actually execute the search warrant because, again, it was out of his jurisdiction. It seems like maybe there could be case law that supports he's not allowed to, but then maybe not. Regardless, the defense says that was Brady information that we deserve to know. That he took this phone forcefully and then was the target of an internal affairs investigation for excessive force. And just to connect it for you, think about everything we know about Proctor in the Karen Reed case. Right? Think about all of the internal affairs investigations that we know about the officers involved in Karen Reed. Defense attorneys use that kind of information to poke holes in the credibility of the investigators who are investigating a crime.
Yeah.
Right. And so they use that information. So when you don't know that information, when that information is intentionally hidden from you, okay, that becomes grounds for the judge to do something.
Yeah, because can't you imagine if we didn't know any of that information about Proctor's text messages?
Exactly.
That would have.
Exactly.
I mean, my
all
goodness.
of that becomes, it's Brady, right? It's Brady. That goes back to the point of Brady. And we talked a little bit about Brady before, and the clip I'm going to show you. So anyway, that's the setup for what happened in the case. So what I want to show you is when the search warrant, when Detective Moretti executed that search warrant at that other office, there was an attorney from the district attorney's office. So Christine Bradley is the prosecutor on Melly's case. This woman named Michelle Butros, I think is how you pronounce her last name. She works in the DA's office, and she was there with Detective Moretti when he executed the search warrant. So she works in the office. Think about, for the sake of YSL, think about Attorney Love and Attorney Hilton, right? They both work in this office. So that is the situation. Christine Bradley works in this office. She's not there. And this woman, Michelle Butros, is there. So the clip I'm going to show you is after the motion was filed in YW Melly. The judge says, I want everybody on the stand. And I just told y'all, when attorneys are called to the stand, it's never a good thing. It's never a good reason. But Michelle Butros is called to the stand because she was a witness to what happened in this room. And so the problem is, I don't think she liked the people that she worked with, because the defense attorney,
finally, I get the
defense attorney calls her to the stand, and he first asks her, what is Brady? How do you define Brady? And so she goes through that. And then she goes through what happened in that conference room. So she's going to tell what I just said. So sorry, you're going to have to hear it twice, but I wanted to set it up. And so this is Michelle Butros on the stand talking about all of that. So here we go.
This Brady obligation. Okay, are you familiar with a prosecutor's Brady obligation?
Yes, I am.
Can you please explain what you believe it is?
In my career, in my practice, I disclose anything that I feel that would cause a credibility issue for a witness, any witness. Credibility, exculpatory, anything that would benefit the defendant at trial, whether it's admissible or not, is a decision that the judges make, not me. You can call it Brady, you can call it a supplemental discovery, you can put it on a paper napkin, but my goal has always been to be transparent and to provide the defense with any information that they deem that they might need at trial.
I'm going to keep playing it, but I just want to reiterate here. You heard the way she described Brady. Okay, it's exculpatory, it's impeachment. I don't even know if y'all can use it, if the judge is going to say you can use it. All I know is I'm going to give it to you. And
if I got it, I'm giving it to you.
And you can figure the rest out.
Yeah.
Okay, so next, she goes through what happens that day.
What happens when he starts the search warrant?
Ms. King reached into her purse and she was fumbling with her phone.
Did you know what she was doing?
You know, it's a phone, so she has this phone. It's, I couldn't tell you what type of phone she had. She was pressing buttons on it. And Detective Moretti was saying over and over again, don't turn off that phone, don't turn off that phone. I knew she was doing something on her phone. I just couldn't swear to exactly what it was that she was doing on the phone. It looked like she was turning off her phone or sending a message or doing something on it. I just couldn't tell. There was a scuffle going on. Detective Moretti physically took the phone from her.
There was no BSO deputy in the room, correct?
Correct.
And this was BSO jurisdiction, the courthouse, correct?
Correct.
Okay. So Detective Moretti did not have the authority to serve that search warrant, correct?
I would always recommend that if you're not in your jurisdiction, that there's case law that suggests that you should have somebody from the jurisdiction that you're serving a search warrant or an arrest warrant in. I haven't done that research for a long time. I just knew that it was probably not what he should have been doing without a BSO deputy there. Eventually, Detective Moretti got the phone from her.
How did you get the phone?
He got the phone from her physically. He physically took it out of her hand. There was physical contact between Detective Moretti and Miss King. And during that physical contact of him taking the phone, Miss King, she yelped. Detective Moretti said to Deputy Morell, "You need to say you were here when I served that search warrant." And it was kind of like an awkward moment. Someone described it just kind of getting punched twice in the head. So there's a search warrant that gets served. And I'm like, what's going on? And then the next thing, he's asking this deputy to lie for him. And again, I'm like, this isn't like, I'm in the twilight zone. Like, this can't really be happening. Yeah, I don't say anything to Moretti. I leave the room. I'm done with the statement. As far as I'm concerned, I'm done investigating this case.
Why?
Because I don't work with detectives that solicit lies. I reported it immediately on that day.
To me.
To Mr. Killoran.
And Mr. Killoran is your immediate superior.
Correct.
Okay, so that is Michelle on the stand.
That nail in the coffin
And
now.
she is saying, this what happened. And this why I'm not on this case, because he's a liar and he's cheating. I don't want him no more. So that happens. And then they next call the actual prosecutor. Okay. She is called to the stand because, again, she is a part of this. And here's the problem, prosecutor. The question is, when did you become aware of this? And how come you didn't tell us?
Yep.
Because if this happened in 22 and the trial happened in 23 and you were aware of it before the trial, you have violated Brady. It's a Brady violation when you don't give it to us. And so she gets on the stand, and essentially that's what they're trying to get out of her is, when did you become aware of it and why didn't you tell us? So that is her coming to this. It'll show up in a second.
The IA investigation is done basically around July 20th of 2023.
I don't know the date on that one. My apologies. I wasn't expecting to testify today, so I didn't review.
Is it a fair statement to say numerous months went by between the time you talked to Detective Moretti and you issued that Brady notice that you said on September 23rd?
That is correct.
Okay. Do you know how many months?
I do not.
Did the trial go on in between those two times, meaning the first trial?
It did.
Excuse me?
It did.
Okay. So you had talked to Moretti about the allegations of his trying to get a deputy to lie prior to the first trial, but you did not reveal that in any Brady notice, did you?
So the discussions were that he denied that any such conversation took place, that no such event happened. But he stated that the deputy showed up, he didn't even know who it was, and the deputy was lost. So there was about 5 or 6 minutes in between when the sergeant had left before the deputy showed up. At that point, when the deputy showed up, Detective Moretti asked him something to the effect of, "Were you outside when this all happened?" Detective Gorell replied something to the effect of, "I can be if you needed me to."
My question really is, you had a discussion with him that he was being accused of trying to get an officer to lie, and this was months before the first trial.
This was at some point, I would say, before April of 2023, yes.
Okay. And then I said you did not turn that over to the defense and you started going into what Moretti said. But based upon Detective Moretti's representation to you, you decided not to file Brady notice. Is that a fair statement?
No, based on Detective Moretti's statement, Deputy Gorell's report that also denied any such thing as had.
So when she was on the stand, I was like, girl, what is you saying? So if that's how you felt, that's accurate. But essentially what she says is, I asked Detective Moretti about this, and his version of events was different than what Michelle Boutros said.
Mm-hmm.
And so for that reason, I didn't mention it because it didn't feel mentionable, because it didn't add up. And based on some other reports that I saw, that's not the way it happened. I'm not going to play the clip, but the reports that she mentions has a different version of events as well, like not the Detective Moretti's version. It leans more towards Michelle's, but regardless, she says, I didn't mention it because I didn't think it needed to be mentioned because that's not what he said happened. And so she never turns it over. The trial happens. After the trial, it's a mistrial. And then the new attorneys for Melly learn. And so they file this motion. And so they have the hearing, and the judge, what he actually rules is that, I just want to find it because
sounds like when everybody was asking about Colin being in the house, and now it's like, oh, we didn't find it significant enough to tell everybody that Colin Albert was in the house before the party or whatever.
So this is what the judge said in his name is Judge Murphy. This is what he said in his order when he recused Christine Bradley. He said, quote, even though it is far from conclusive, the court is sufficiently concerned about whether Miss Bradley has departed from her role as a zealous advocate for the state and is now personally invested in the credibility determinations of Detective Moretti and Boutros and the outcome of this trial. And so what he ruled is, I don't really know. He didn't even rule on the fact of if Moretti really did that, if he's credible or not. But based on the way she handled this, there is enough concern. Okay, there's enough of an appearance of impropriety that you don't get to be on here, because it looks a little like you have now gone onto the side of you're invested in making sure he is found guilty instead of justice, instead of the truth. And for that reason, you can't be on Nostromo.
Yeah, I totally agree.
So, okay, I said all of that to go back to YSL, because what happened in that ex parte, okay, regardless, now the defense has said, okay, Jeffrey Williams, Brian Steele, all of the defense attorneys have said that there was Brady material that Kenneth Copeland said in the ex parte.
Yep.
Okay. And so I can play the clip of them talking about what happened in that ex parte. I can play the clip in a second. But what it comes down to, in my opinion, and I'm not a lawyer, is that they have enough evidence and support for the prosecutors to be recused. Even if you just look at the YW Melly case, in my opinion,
mistrial.
Whether you coerce Kenneth Copeland, it gives the appearance of coercion. It gives the appearance that y'all went into that room to convince him to get on the stand. And that to me says you are now, you have departed. I'll take the words from Murphy. You have departed from your role as a zealous advocate for the state and are now personally invested into the outcome of this trial. And that is what I think that ex parte, the fact that it happened. And on top of that, the fact that after it happened, nobody told them that it happened. The fact that Brian Steele had to be threatened with court, had to be threatened with 20 days of jail, had to be held in contempt. The fact that all of that happened is enough. In my opinion, and I'm not a judge or a lawyer, but I think you have enough basis for at least I know there is a request for a mistrial. Mistrial is there are levels to this, okay? There are big asks. At the very minimum, I think that it is appropriate for the prosecutors. And actually, you know what's so interesting? I don't even know if Love is as much of a problem in this as Hilton is, because Attorney Hilton from the prosecution of YSL, she was the one that was participating in that ex parte. Love was actually gone for most of it.
But she was there and she knew it happened though.
Sure. But the parts that are problematic of it was Attorney Hilton. I think it's appropriate for her to be removed.
So this case law.
Am I a lawyer now?
I was about to say, who found this case law?
Me. No, I'm just kidding.
That's what I was about to get at. You did this?
Well, yeah, I did, because I followed the YW Melly case all through and through. I went and I had to go back.
What
and
I'm saying is,
recaps.
has YSL presented, any lawyer in YSL presented this?
No, I'm finna DM them. Yo, let me tell you what I did.
Hold on now. what you just did.
Okay, but it was in Florida though too.
You're
You're
about
better-
to, you about to be Exhibit H.
No more exhibits.
You gonna be in Exhibit H. They're watching this when it does post. I guarantee you, this
No.
case
Well,
law
here's the thing. It's
is
better.
about to be presented because it's flawless.
It's
It's hand in hand.
I agree. It is very clear, again, that there is basis enough for the prosecution to be removed. And I will say, I don't know what Judge Whitaker is going to rule, okay, because she keeps going both ways when it comes to it. It's hard to tell as far as the mistrial is concerned. But I think that she is seriously considering recusing the prosecutor. I wouldn't be surprised if she says no to the mistrial, but recuses the prosecutors. I actually believe that is on the table. And there's a likelihood of it.
She is fighting to me to have this trial continue. But with all of this evidence, keep the ex parte meeting, this case law, when she gets a hold of this, it keeps like, dang, y'all, I'm trying here. This is too messy. And then if you recuse the prosecutors, then you need to go get more prosecutors, right? Or recusing them means they're just going to get on the stand.
Well, they have an office, right? It's the district attorney's office. So everybody under Fonnie Willis, it's her office. So if Love and Hilton were removed, they would get another prosecutor. They could even call Fonnie Willis herself to prosecute this case if they needed to. Like they could get other, because the thing about, here's what was interesting about YW Melly. When they asked to recuse Christine Bradley, the prosecutor from that case, they had also asked to recuse the entire DA's office, that entire county's DA office. So you would have to recuse an entire office for it to have to go somewhere else.
So they would just recuse them and then bring the other prosecutors up to speed as they did the judge.
Well, so what happened in Melly, mistrial, but there's still going to be a second trial. So they just assigned new prosecutors to this case. She had to get caught up. She did a couple hearings and then obviously it was put on hold, but it's just like the Judge Glanville was recused on YSL. You get a new judge, you catch you all up, and then you keep it moving. So that's essentially what they would do, is just get some new prosecutors from that same office, have them caught up, and then move forward.
Mistrial, man.
So
that's just another. Come on. That's hey.
I did that.
That's good.
But the other thing, and so this is the other thing I kind of wanted to highlight with YSL, is that in that I'm gonna play Kayla Bumpus's testimony, because Kayla Bumpus, the attorney who was representing, I'm telling you, when attorneys are called to the stand, you know you've reached a point of no return in a trial. So Kayla Bumpus is called to the stand, and the point of her testimony is to recount what happened in that ex parte meeting, right? She is up there to talk about really if there was Brady, because that's what it comes down to as well. There's so many parts to it, but the prosecutors even participating, I feel like, is grounds enough, because they have transitioned from, just being a zealous advocate to now being personally invested and coercing the witness. But the other part of this, if there is actually Brady material that is said, and it goes hand in hand, because if they prevent that from coming out, that's prosecutorial misconduct. But if what was said in that meeting by Kenneth Copeland could have been used to show that the defendants didn't commit these crimes, again, they have the right to know that.
Yeah.
So hopefully you guys are following what I'm saying. I'm not all over the place, but I'm going to play Kayla Bumpus's testimony just so we have it in our minds.
Simone starts to talk to Mr. Copeland about, she reiterated the fact that pretty much she wanted him to testify. She didn't know what he was going to say, but there was one thing that they know that he didn't do that she would not allow him to testify to. First, Mr. Copeland said, I can claim all of this. I can claim all of this. I might as well just say I did all of this. And she said, but we know you didn't do all of this. And specifically, we know you did not kill Donovan Thomas. And I will not allow you to get on the stand and say that you killed Donovan Thomas.
Did she say anything else with respect to that?
I was explaining to Mr. Copeland about independent evidence, because she said if she had any independent evidence to prove that he was lying, about anything. She would just use his statement to impeach him, but she would not necessarily press charges against him for perjury. But she said that if he said this thing, this one particular thing, which was the unaliving of Donovan Thomas, that she may move forward with perjury. And Mr. Copeland says, well, it's not just about me knowing who killed him, but it's about, I know more about that infinity, and I know something about somebody who's not even on trial.
So what she, oh, go ahead. You were going to say something.
That was almost like leading him to the answer, saying, hey, I won't let you take the rap for this because you didn't do that.
Yes.
You know what I'm saying?
Yes.
When he could have, but you didn't do that, did you?
Yes. Well, and not only, here's the thing, not only leading him to the answer, but then threatening him. She said to him, what Kayla said is, Attorney Hilton told Kenneth Copeland, and actually, I'm gonna back up just a little bit. Kenneth Copeland is given immunity.
Yep.
He is given, you can testify about any crime you were involved in and we won't prosecute you. So in one regard, Kenneth Copeland is like, okay, well, I'm going to say I did all this. I'm going to admit to everything. Okay. Cause I got immunity anyway. So then what? And then he says, I'm going to say it includes, it's not really clear what the exact phrasing was, but at some point he includes in the claiming of all of this, admitting to Donovan Thomas's murder. I'm going to say I did that too. And so then Hilton says, well, hold up now. Okay. Oh, everybody relax. You can admit to everything but that. Because if you admit to that, then I'm going to charge you with perjury. That's where I draw the line. You can admit to all the other crimes. I won't charge you. I'll just say you're a liar. But if you admit that you killed Donovan Thomas on the stand, I'm going to charge you with perjury. So it's more than just leading him to the answer. It is now threatening him, okay, with his freedom being at risk, okay? I'm going to charge you with a crime.
Yep.
If you get on that stand and say you did this and I know you didn't, or I believe you didn't. I don't really know what you know,
you can't say I know you didn't.
But that again, coercion. That again,
and you're able,
problematic.
Yes.
What you mean? You telling him you're okay with him lying, but this one thing he can't lie about because you are saying our clients did it, because you are saying the defendants did it. I can't risk that lie. That was not okay.
And then his lawyer isn't there to defend him in any
type
of way.
Well, Caleb Bumpus is there.
Oh, well.
He has representation, which again is a part of the attorney Love and the prosecutor's position, is that he was represented. His representation was in that meeting. So we don't, if whether she knew or didn't know or spoke up or didn't spoke up, she was there and that was his representation. So we weren't doing anything, saying anything too shady. At this point, the judge says, y'all gave him a ton of information that was incorrect. So y'all were wrong. So regardless if Caleb Bumpus told y'all was wrong, the judge was also there. Here's the other thing. They gave Kenneth Copeland in that ex parte incorrect information. And not only was Kayla there, the judge was there. The judge was in that meeting when they are telling him, if you don't testify, we're going to get to hold you until everybody on this indictment has their case.
Yeah.
Wrong. That's wrong information. When they're telling him about what the immunity is, wrong information. And the judge is sitting there.
Yeah.
It's actually really crazy.
That's what I'm saying.
When you think about it.
This is wild. And Bumpus didn't even stick up for him. She's just sitting there.
Well,
is this a meeting?
No, well, but to be fair, here's where I want to be fair to Kayla Bumpus. Number one, she was a stand-in attorney who was unfamiliar, and her understanding of her role was to come to court and ask Kenneth Copeland, are you going to testify? If he says no, or if he says, but that was the extent of find out if he's going to testify.
Okay.
If he testifies, you are basically relieved. You don't have to do anything. If he says no and they take him back to jail and hold him in contempt, then wait till I get back because we got to figure this out, essentially. So she was unfamiliar, unexpecting, and then got there and I think just unaware. And I think she came and a lot happened and she was not prepared for what was going to happen.
Yeah. She didn't know she was walking into a zoo.
Yes.
Yeah.
So I just want to be fair to her. So anyway, all of that to say, I didn't forgot my whole point.
The judge was there. No one. They was giving him so much information, wrong information,
Yes.
and allowed it to happen. And they were basically threatening him.
Yes. And so he changes his mind and gets on the stand.
Yes, to testify
to no one's
for
surprise.
them. Yeah.
Yes, to no one's surprise. So anyway, I just wanted to set that up and say that, that was my point. Brady. The point is that him talking about this infinity and that there could be somebody else, and him potentially in some regard admitting or taking responsibility for Donovan Thomas's murder is information the defense has a right to know. Granted, it's still unclear if I think the testimony has not been that he said, I did it, but I can go up there and say I did it. I think regardless, the conversation deserves to be known by the defense. Now, what it comes down to.
Now, you just said Bumpus was his lawyer.
Yep.
Is she not the defense?
No, he is a witness. He is not a defendant in this trial. He is a witness.
I'm not understanding. Bumpus was Woody's lawyer, stand-in lawyer.
Yes. And Woody is not a defendant in this case. He was only a witness in this case. So she should not be on the side of the defense. She should be on the side of Woody and making him his experience of being a witness and testifying as seamless and pleasant as possible.
Because this isn't a trial against him.
Exactly. He is not charged. He is not a defendant. So and it's her and Melnick, right? His actual attorney is John Melnick. And so they are just supposed to be representing his best interest.
Yeah.
So that's that. And again, why I would argue, and I'm not a lawyer and I'm not writing no motions or citing no cases, but why I would argue that there is enough grounds for them to be recused. Now, something else happened yesterday, and that has to do less about Brady and more about discovery. Okay, because Brady, they have a right to know. Discovery should just be turned over, right? And so the defense in this case has been saying for a long while that the state turns over their discovery very late. They ambush, essentially. They wait until the witness is about to come up or is already up, and then they turn over information regarding that witness. And so they have complained to the previous judge, Chief Judge Glanville, to say, yo, can you do something about this? And so that is essentially what came up yesterday. And I'm just going to play the clip because it's actually interesting the way it came out. It was the very end of the day. And Brian Steele says this. Hold on.
We're in chamber. Simone starts to talk to Mr. Copeland.
Hold on.
All right. Anything else before we break for the day?
Just for your edification, we'll file a written motion. The state yesterday gave us a Dropbox link, and it includes additional telephone numbers that I was unaware of.
Okay.
Where an expert, he's already been qualified. His name is Agent Bernie, Berni, from the FBI, has done now an analysis of historical cell site location data. And I'm objecting to that very late, I believe, notice I am not agreeable to.
Okay, an entirely new phone number. Tell me some more, Miss Love.
Yes. There was another person in the vehicle during one of the murders in this case that investigators were still investigating during the time we began this trial. They were trying to hash out whether or not this particular person was even in the car. During the course of this trial, the investigators with the Atlanta Police Department determined that this person, I don't think that person has been arrested, but this person was also in the car with the co-conspirators during this particular murder.
Okay.
We got it before now, but we got it after the trial began.
We were given cell phone records linked to a last name Boyer Monday on yesterday. And so that is the late disclosure that we're speaking of.
When did you find out that law enforcement believed that there was another person in the car and had a cell number that they were going to investigate with regard to that to find out whether, in fact, that was a reasonable lead?
I'd like to check with another team member.
Okay.
All right.
About
I keep doing this. So essentially what happens, okay, I won't play the full thing, but essentially what happens is that on Monday of this week, the state turns over some discovery and they don't point out, hey, this is the new addition. You ever get something and it's not highlighted what's different, so you have to like comb through to figure out where the difference is? That's essentially what happens. And so they discover this phone number in this discovery that is like, wait, what is this? And there's also some reports about it. And so what it has to do with, there is the murder in this case that they've talked about the whole time, which is Donovan Thomas, but there is another murder in this case, and it's the murder of a man named Shymel Drinks. And this phone number has to do with that murder. So what happened, according to the state, is that there's two cars and when it comes to Shymel Drinks murder, there's two cars, and some of the defendants are in one car, some of the defendants are in another car. This murder happens, and so that's why they are now on trial. What Attorney Love says is there was this other person that we thought was in the car, but we wasn't for sure. And so this phone number is this other person's phone number. And so we got his phone records and we were like, oh, shoot. When you look at his phone data and the pings, he was in the same car as he was there on the murder. And so she says, we have been investigating, but we didn't know at the beginning of trial, between the beginning of trial and now, that's when we found out. And so the defense is like, they just gave us this. And so Brian Steele says, essentially, I could have opened on this. I could have that part actually feels like Brady, because
I was about to
he could say this other dude was in the car. He is the one who did it. Right. And so so he's like, it's Brady. Attorney Love eventually says, we didn't have it at the beginning of the trial, so you couldn't have opened on it because we didn't even have it. But regardless, that is kind of what happened yesterday. And the judge says, I want to know when you got this information.
That's my question.
I want to know, okay, when you even had the thought that this person could have been in the car. So it kind of ends heated. Okay, that's how Tuesday ends. And then today, which is Wednesday, we're recording this podcast, they pick up with it. The judge is like, what you found out? Tell me what you did. And so what's interesting is that according to her and what she looks up, she says that this information was actually turned over to them in 2022.
Really?
That's what she says. Here's how she turned it over, though. Here's the problem. The way she turned it over makes no sense. Okay. She had been turning over batches, right? When she turns over it's a lot of discovery. So again, they're combing through stuff. So what she says is, we gave them the phone number in 2022. We didn't tell them whose number it was, but we said that, like, hey, this, you should be on notice. And then later on, the team provided them a jail call in which somebody in jail calls that same number. And so in that file, she identifies that number belongs to this man. And so she says, we didn't give it to you all at the same time, but we gave you enough puzzle pieces for you to be able to figure it out.
So they can put it together?
Literally, that's essentially what she says. But she says, we don't plan on using this anyway. And so for that reason, the judge rules, oh, okay, if y'all don't plan on using it anyway, because Brian still filed a motion that was like, it should be excluded. He essentially was asking for it to be excluded. But because she says we don't plan on using it anyway, the judge says, okay, your motion is granted, but it's unnecessarily granted because they're not going to use it anyway. But that was just another example of a pattern in which the state has been shady.
So we literally have an individual out there that's just
who they say was in the car with them, and is not indicted on. Is not.
That's what I'm saying.
100%.
He or she is just.
It's a he. No, he's not. Yeah.
Wow, and he's potentially. He could be the shooter, or where he probably knows what happened.
He deserves to be questioned at the very least.
That's what I'm saying.
Deserves to say, hey, I want to talk to you. If you have an attorney, I want to talk to you and your attorney. So that happens. And then
wow.
After the judge squares that away, Brian still brings up another report that has to do with the Little Wayne bus shooting, in which he says, here they go again. They had this report drawn up regarding the Little Wayne bus shooting, and they never gave it to us. And all of a sudden it's just dropped off. And it's just indicative. It just showcases the way that they handle discovery. It's late discovery. We feel ambushed. We can't prepare. We don't have time. And so the judge basically gets upset at that point and says to Attorney Love and the prosecution team, I need you to go find out if there is any other discovery that you have not turned over, because you better turn it over or you're going to have some problems.
So is it discovery because they just discovered it?
It's just discovery is just evidence.
But what I'm saying is Brady is evidence. I know of this evidence and I'm not giving it to you. Evidence, because it could probably hurt my case. Discovery, I have this evidence, but is the difference between discovery and Brady, is it the time that you find out that you have it?
So Brady specifically is, I can replay her clip. It is evidence that can be used to, it's exculpatory or not, but it's evidence that can be used to help the defense specifically, right? Like, let's say, this may be a bad example because I'm not a lawyer, but let's say I have evidence that you were at the store at 5 o'clock. I have video footage of that. That doesn't, and maybe both sides agree, yeah, he was at the store at 5 o'clock. That is evidence that they have to turn over. We have it. But that doesn't necessarily, it doesn't necessarily help the defense's case. It doesn't necessarily show that, you didn't do X, Y, and Z because that happened at 6 o'clock.
Yeah.
But so evidence is just evidence of, the situation, the circumstances what's surrounding it necessarily. But Brady specifically, I want to focus on Brady. Brady specifically is information that can help the defense.
So Attorney Love is finding discovery batches of evidence which could contain Brady, but she doesn't know, or no one knows until they comb through it. But here's this big batch and you find it if you can.
Sure.
Basically.
And not finding. I wouldn't say finding. And actually, here's what she says. Here's what Attorney Love eventually says as to what this mix-up is. What happens is new Judge Whitaker, is on the case, and she operates very differently than Chief Judge Glanville operated, the judge that has been on this case previously. He was all over the place, not organized, and he let everybody do what they wanted to do. Judge Whitaker don't roll like that. And so what she said last week is, hey, state, I want to know who are your next 30 witnesses, and I want to know the evidence that you are going to present. What are you going to have as exhibits connected to each of the next 30 witnesses? I want you to bring it up here. I want to see it, and I want to comb through it. What really happened, it seems less intentional and less malicious, is that because they finally had to start doing work in the state's office, they were like, oh, shoot, y'all. This is one of our witnesses, and we didn't turn this thing over that we were supposed to turn over. And they discovered it because the judge made them do work.
Okay.
And so in that discovery, one of the attorneys says, she literally says, oh, shoot, I didn't turn this over. And so what it seems like they did is say, hey, here's the batch, brother. Let's just add this in here and see if they realize it wasn't in here. Here you go. And that's what actually seems to have happened.
Okay.
But it's, again, because now that they are on notice that they have to work.
Yeah.
That they have to, hey, you can't just pull up the next witness and we're just on the next witness. I need to know who your next 5 witnesses are. And what is the information, the exhibits, the evidence connected to them that you are going to try to get in.
Yeah.
So that I can rule on it. So anyway, that was a lot. Okay. I hope it was interesting for you as you listened. We will see. The judge is expecting to rule on NYSL. She's expecting to rule on the mistrial motion before Monday. I'll tell you that much, because she is right now saying the jury will be back on Monday. Kenneth Copeland will be called to the stand. She asked him if he's going to testify, and he said, it depends on how I wake up. So
I'm about to say they need to leave this man alone, man.
if he wakes up on Monday and comes to court and they say, are you testifying? And he says, I plead the 5th, he will go to jail. If he says, yes, I will testify, then we will get another week of entertaining, I'm very sure, entertaining testimony from Kenneth Copeland. But as of now, mistrial motion ruled on this weekend, as well as prosecutor's recusal. I think that has now been reopened. So we'll see if she rules on that. And then if all stays as it is, Monday morning, we're going to have a jury in the box. They had Copeland on the stand if he wakes up and says he wants to be.
They have this illegal meeting where they threaten him. We all know what happened, and they still are threatening him with jail if he pleads the 5th.
Well, that's a little bit different. I think what you're comparing is different. When you have an order of immunity, you will go to jail if you don't comply with that. That is.
But he complied because of.
Yeah, but and so what she said is, y'all gave him incorrect information and got him to agree to get on the stand.
Yep.
She brought him into the courtroom yesterday and said, I want to give him the correct information and see if he wants to testify now that he has the accurate information.
Okay.
And so before he was told, which was very clear, before he was told, if you don't testify, we can hold you in contempt until everybody on this indictment has their cases. Yep. What she told him yesterday is that was wrong.
Okay.
If you choose not to testify, we can only hold you until this trial is over. Okay. And he actually was, I feel like, very intent on that part. He said, so just this one? She said, yes. Not everybody else. She said, no. So I think that alone could impact his decision.
Yeah, it is.
If he's willing to stay in jail for a couple months versus thinking he would have to be in there for years, that may have impacted his decision, which in my opinion, again, speaks to coercion. Literally, that's the point here. So they gave him proper information and she said, do you plan to testify? He said, we'll see how I feel. So
yeah, they need to clean up their act. So
I think at the very minimum, they should be recused. That was the point. I'm happy I have this podcast just so I can tell you all my own thoughts.
I don't think he's going to testify. I think he's going to go sit down for a few months.
If he does not testify, I think that is grounds for a mistrial, because I think that turns it up a notch, because I think that it shows the information that he was given, which was incorrect, was used to get him to testify.
He ain't going to testify because the young man still has to walk around.
No, I'm just kidding.
He still has to walk around Atlanta after he testifies.
Well, he's proud of that. They were like, did you leave? He said, I ain't went nowhere. I'm in Atlanta. I said, okay. Okay. That man said, I ain't going nowhere. This is where I stay. Y'all gonna have to come see me. If you want me out of here, come see me.
He ain't about to testify. He gonna sit down for it could be. And that's the thing. He can sit down for a few weeks to a few years, but it ain't gonna be that long.
You mean for him?
This trial is not going to take 2 more years.
No, she said right now it's projected. Well, she said the way she's rolling, I don't think the trial is going to take as long as it was previously. But she said February, March is expected to be over. So if he don't mind missing Christmas,
yeah, I'm quite sure he don't miss some Christmases before.
He has. He's spent a lot of time in jail. All right. Thank you all for watching and listening. If you are on audio only, we appreciate y'all. Please support the sponsor. Support them. Support us. Use the code. Even if you're not a lawyer, use lawyer code. Use code lawyer, not lawyer code. And we will be back to see what we're going to talk about next. Join the Patreon if you are not yet, because it's a good time. We do live watches of some trials. We talk about a lot of things. I put documents in there, do the whole shebang. So
please
join the Patreon. Please. Thanks for watching. What you got to say?
Thank y'all for tuning in.
Take us out.
Court is adjourned.